calling People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Good morning, Your Honor. Habib Balian for the people.
Proceed.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principled objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
What do you think of the people?
I don't have the list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Counsel for 4 and 10 present?
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are here to issue and hold a body attachment.
And counsel for number 4?
In counsel number 10's statement, I don't see the necessity for issuing a body attachment. I too will stipulate the jurisdiction without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Fair enough. As to
Thank you, Your Honor. And just to be clear, we do also reserve all of our objections.
yes, and so, but as to the remaining numbers, that's 1, 2, 3, 5, 6, 7, and 8. Those the court will issue body attachment and hold it until the next court date.
And
9.
thank you. We have no objection to counsel's representations, given the fact that both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
Thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9 until the next hearing date. And
Does the court have a list?
It does. The court will seal that list as well.
We've asked
people have a copy or not?
We've asked that the court seal it specifically because it is ongoing defense investigator data or evidence that we recover or we get, our counsel on behalf of Mr. Reiner gets, and that is discoverable. We'll comply with all, or counsel will comply with all discovery obligations at that time.
Can you address the counsel's request to provide a copy to the people?
That's the point. We think that should not be done because that would implicate ongoing investigative efforts by the defense, and it would compromise Mr. Reiner's right to a fair trial and his right to maintain his investigation with some level of confidence or confidentiality, I should say.
But at this time, the court would just seal it until the next court hearing date.
Thank you.
And how else would you like to proceed?
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here. They're staffed. They're ready to take over. My understanding is they are ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will case, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
Thank you, Your Honor.
Current counsel turn over any items that they received.
We will absolutely comply with that. We've already begun. The mediation has been met.
Your Honor, there's a protective order issued by the court in place regarding the handling of discovery. Order that's remaining in place for now, and we will serve a copy of that on the Public Defender's Office along with the discovery we provide.
Yes, the court will order that order.
Preclude me from giving. Mr. Balian raises a very sage point. I'm under a protective order not to provide our discovery to anybody else. That would text providing the information only to Ms. Green in her office. Then I can be in full compliance with the protective order.
Anything to the people? Any response to that request?
No problem. I believe the protective order spells out that it covers Mr. Jackson's firm as well as any successor counsel.
Thank you.
So you can provide everything to Ms. Green.
Thank you.
Back on the record in People versus Nick Reiner, case number 25 CJC F08098.
This morning, Kimberly Green here at ENE for the Public Defender's Office on behalf of Mr. Reiner, who again is present.
Thank you.
Good morning, Your Honor. Habib Valian, representing the people of the state of California.
Thank you.
Your Honor, with the court's permission, we'd ask to put over the arraignment one last time to February 23rd, if that date is appropriate.
That date is fine, court.
Thank you, and I will work with Ms. Green to get her discovery prior to that date.
I'll take a waiver for your entitled, you have a constitutional and statutory right to a speedy arraignment. Your counsel, Ms. Green from the Public Defender's Office, is requesting that your arraignment be continued to February the 23rd, 2026. In this department, do you waive your right to be arraigned today so that your matter may be continued to February 23rd, 2026 for arraignment? Thank you. And is counsel joining that waiver?
I do,
The court finds that the defendant has made a knowing and intelligent waiver of his right to a speedy arraignment, and that his counsel of record joins in that waiver. Matter set for arraignment in this department, February 23rd, 2026. Bail remains at no bail.